I'm really grateful to the organizers. It's a wonderful event. I'm learning a vast amount, and I'm sorry to have a slight, we're going to have a slight recess between learning. We'll just have to, another 20 minutes we'll get back to learning. Fun, exciting abortion stuff coming up, so stay tuned. And I'm grateful to Rabbi Broid. I've always learned a vast amount from him over the years. Still do. It's fascinating stuff. I mean, one of the things, in connection to his talk, one of the things I say to students, I just said it to a lecture to LLM students about a week ago, is that whenever I say anything, whenever I or anyone else who's a law professor says something, you know that there's immediately a footnote, because when we're talking, you don't always see the footnote. And whatever your general proposition is, there's a number of complicated exceptions, caveats, cautions. I know that Rabbi Broid properly said that no appellate court has invalidated or limited the New York Get statute. He's, as any good law professor is, very careful. He says appellate court, because there's a number of trial courts who have said we will not apply it in circumstances where there's no indication that the husband is using this to leverage a better settlement. And regarding Utah, he says Utah will prosecute you for religious marriage. I don't know. You know that everything crazy is on American TV. There was actually a popular show on American TV called Sister Wives about polygamous family, and some prosecutor took it into their mind to prosecute them. And they had this sort of situation: one legal marriage and a number of religious marriages. They prosecute them, or at least were talking about prosecuting them, and they brought the Sister Wives and company brought a federal lawsuit saying that's nuts, right? We're not actually bigamists. We have only one legal marriage, right? The rest is just, as Rabbi Broid says, cohabitation. You can cohabit all you want in most states. And in fact, what happened in that case is the Sister Wives won below. They won the case. And then before there was a disposition on appeal, the prosecutor said, I'm not going to prosecute them. So they get mixed messages. Maybe we'll prosecute you, maybe we won't prosecute you, depending on what's in our advantage at the moment. The Holmes case, I think, that was a police firing case, wasn't it? So different issues. My topic, as stated, was religious family agreements, recent U.S. cases. Now, recent, of course, is a lovely ambiguous term. I learned when I studied in England that recent means anything after 1500. Of course, here in Israel, it might be, 1200. For me, the United States, with the law ever changing, I cover cases from 2000 on. I tried literally to track down every published case and every unpublished case available through the electronic search services dealing with this topic. I'll tell you more about the topic in a moment. And as with Rabbi Broid, please feel free to contact me. Email is easy. You can find it online, but also it's my last name, Bix, and then add UMN. U is UM, a little tricky. M is a Mary, N is a Nancy. UMN.edu, the first 3 letters of education. Happy to send you the paper. Happy to send you other papers. Happy to discuss recent sporting events, whatever you like. So, religious family agreements, recent U.S. cases. The religious family agreements, right? We need all 3 adjectives. The religious family agreements tend to be of 3 categories. They tend to be provisions from Islamic marriage contracts involving Mars. It also has different siduk, mayor, different names. Anyways, the provision in an Islamic marriage contract common across different Islamic communities where the husband about to marry gives his wife to be or his wife a very small payment or gift with the promise of a significant delayed gift. And the delayed gift is due if he, under a number of conditions, generally if he divorces her through triple talaq and some other conditions as well. Basically any divorce where she's not significantly at fault. And there's a growing number of cases where there are efforts to enforce the MAR provision. And it tends to be either the wife wants to enforce because it was a real lot of money, or the husband wants to enforce it not because he's in a rush to pay the money, but because his argument is that that obligation, that second MAR payment, constitutes the entirety of his financial obligation, preempting any other alimony, equitable property division, or so on. So that's one category. Second category is just the sort of things Rabbi Broid was talking about, the ketubah provisions, especially the ones that set up a promise to pay a certain amount of money. It used to be $100. The version I've seen more recently is $150 a day for every day the husband fails upon request to make to provide a religious divorce again. The third category, and this is actually a much smaller category, much smaller than you would expect, are religious upbringing agreements. An agreement, usually in a separation agreement on the eve of divorce, but also sometimes in premarital agreements in which the couple agree that the children will be raised in a particular way, raised in the Catholic faith, raised as according to Orthodox Judaism, and so on. And the largest part of the paper, and perhaps the most interesting part of the paper, does deal with the MAR, because with the MAR provisions, there are overlapping questions, right? One of them is under U.S. law. Rabbi Broid talked about this. There are, at least allegedly, limitations on the way to which the state should establish religion, or as elaborated by earlier Supreme Court decisions, become entangled with religion. All right? And in response to that, with cases like some of the ketubah cases, like some of the MAR cases, what the court, and indeed earlier than that in cases involving church property and various contracts, what the courts developed was the idea that it won't raise an entanglement issue or an establishment issue if the court is merely applying neutral contract principles. So there's a handful of MAR provisions where the wife is seeking enforcement and say, oh, it's a standard contract. The husband is saying, if you marry me, marriage has consideration, if you marry me, I promise you gifts. Right? It's parallel to a famous American contract case. If you don't drink or smoke for 5 years, I'll give you a whole bunch of money. Right? And at that level, they say, yeah, it's a contract and it's unproblematic. I don't have to make any judgment about Islam or any other religion. I'm going to enforce it. The cases where the husband comes in and says, I'd like to enforce the MAR provision because it preempts any obligation I have to pay alimony or equitable division of property. That's problematic at a whole bunch of levels. Many of these cases involve parties who signed the agreement, and the agreement was written in Farsi or Arabic or some other language they happened not to be able to read. And no one really, and if it was explained to them, it may not have been explained at all or explained in only the vaguest sense. So partly is, and the language of MAR provisions is a fairly sort of standard language. It's not very ornate or intricate. It's, I pay this, you fill in the form. I pay blank now. I, the husband, pays the wife blank now, and I promise to pay, blank later. All right? That's it. That's sort of the beginning end of it with some flourishes, but not much. All right? And the problem is for the husband to claim that the parties intended to thereby waive alimony equitable division is problematic at a whole bunch of levels. Partly because these were often, in a number of these cases, these were parties who signed it in Iran or Syria or Lebanon, communities that don't have, as we understand it, alimony equitable division. And we sort of talked about this a bit in the earlier sessions, that often, I was pleasantly surprised to hear that some of the Sharia courts are developing support provisions for the wife, because my understanding is, at least in some communities or in some past times, it was just understood the wife goes back to her family. They get the support, right? If you're in a community that doesn't have this, right, the notion, you wouldn't know to waive it. You wouldn't know that you're like, you can't, you're getting married in Lebanon and Syria. It's hard to imagine that 15 years down the road, you'll be in a court in Maryland wondering what your claims are for equitable division. And so partly it's just a question of intention, and what possible sense could the parties have an intention to waive, an intention to do anything whatsoever to a set of legal rights they had no reason to foresee? But more importantly, perhaps, for the sort of work I do, is I work on, one of the things I work on is pre-marital agreements. And these MAR provisions are often treated as premarital agreements because they are often, as a pure matter of technical chronology, signed prior to the official marriage. Therefore, signed, from the Islamic perspective, they're marriage contracts, beginning and end, that's it. But from the American context, there are agreements entered by parties about to marry, where at least one party is subsequently claiming that they were trying to waive a right of divorce. And by the way, it doesn't work better if the chronology comes out the other way. There are a couple of cases like that where the couple enters a civil marriage first and then has the religious ceremony. So then the MAR provision is sometimes called marital, sometimes called post-marital. Either way, the post-marital agreements are actually treated more harshly, more with greater suspicion in most states. But either way, if you're coming in and saying, we entered this agreement which purports to waive, at least as I'm interpreting it, purports to waive rights at divorce, pretty much every state says in principle such agreements are enforceable. They're enforceable if you've jumped through a certain number of hoops. Some amount of financial disclosure, some opportunity to speak to a lawyer, a clear explanation of the rights you are waiving, and almost any of the requirements that the states have imposed, these agreements don't meet. So we're supposed to meet them. It was an agreement in the Islamic tradition meant to do what it did, which is get the parties married. And so most of the courts end up saying that to the extent you're claiming that this is a waiver of rights, we're not going to. You haven't met a valid premarital agreement. The courts are all over the place. Some of the courts say, maybe it's valid, but then it's contrary to public policy. It's unconscionable, right? Even if it's otherwise procedurally okay, you're saying the wife has effectively given up a whole bunch of stuff, and that's just premarital agreements are invalidated in that purpose. There are some weird cases. There's a case where the husband claimed that the MAR provision, as part of the Islamic contract, and again, I pretty much told you the full content of that contract and many of the contracts, right? There's not a lot to it. He claimed that provision should be understood as a choice of law provision incorporating all of Islamic law. Courts spend a lot of time kicking that around, but eventually said no. And by the way, there's a ketubah case that tries to do the same thing, where the husband comes in and says this fairly standard-looking ketubah, which didn't even have a pay $100 per day sort of thing. This standard-looking ketubah incorporates Torah law, right? Not Judaic law, but Torah law. And then the court didn't have a lot of time for that either. Again, in part, on those cases, again, the court is going to get a little edgy about entanglement. Look, we, the secular appellate court of the state of Maryland, are going to apply Torah law? No, thank you. Again, it's a different matter, as Rabbi Roy points out. It's a different matter if you want to enter an arbitration provision, hand it over to the rabbinic court, and then come back. As Rabbi Roy says, once you're in arbitration, that's it. The Federal Arbitration Act, the State Arbitration Acts are highly, highly deferential. And one of the ways it's very hard to defeat an arbitration judgment at the best of times, arbitration decision at the best of times. But if your argument is the rabbis got Jewish law wrong, right? No chance, right? No chance. No chance is the court going to say, yes, we think we're going to invalidate this because we think the rabbis got it wrong. So fortunately, I've already used up all my time. Isn't that great? So let me read the conclusion. The recent treatment of religious agreements in American family law shows the tensions created by an intersection of separate concerns, interpretive, doctrinal, and constitutional. All three are present with marked provisions, though in some ways what is most salient is the interpretive question. It is genuinely difficult how to understand the intentions, implications, and applications of a marriage contract which may have been entered into the context of a very different set of legal standards and social expectations. On the whole, I think that most American courts have been correct in their approach to moral agreements, that to the extent one party wants to treat these agreements as waiving or altering the rights, then they must meet the protections of state family law doctrine. On the constitutional issue, the courts largely agree that Islamic or Jewish marriage contracts can be enforced when this can be done on secular, religiously neutral principles of law. As the courts have generally concluded, this can include requirements to pay certain amounts of money, monetary penalties for delay, and deference to religious arbitration. For religious upbringing provisions, which I didn't really talk about at length, it appears that the courts in most states are reluctant to enforce such provisions, though there is little case law one way or the other outside of New York State. Where the provisions are enforced, the courts are cautious to disentangle provisions relating to how the children are treated, religious-based constraints on what schools they attend, what religious services they go to, which foods they eat. They disentangle that from any constraints on the parents' action, which are separate from such upbringing. There is every reason to believe that courts will continue to search for ways to apply neutral secular principles when faced with religious marriage contracts, provisions agreeing to religious arbitration, and agreements regarding the religious upbringing of children. And when courts are pressed to second-guess a religious arbitration panel or interpret the meaning of an agreement to apply Islamic or Jewish law, they will simply and wisely refuse.